Welcome to Session 7 in our series, Estate Planning Solutions for Families. This is going to be a really interesting session too. It's about medical directives and what it actually does. You'll also learn about HIPAA and how that can affect your family, and then applying these to your estate plan. So let's get started. We're going to talk today about exactly what a medical directive does. There's a myth that you get to decide what happens to you under various medical scenarios. Actually, that's not true at all. You're only making one decision here. The medical directive form is designed to let the doctors know what your wishes are if you are on life support. That's it. If you are on a machine and you are incapacitated and there's no way you're coming back, and there's no way to live without that machine, you can decide yes or no with this medical directive whether I want to stay on that machine or not. There's certain religious mandates that are out there, for certain religious rites that have to happen during passing. But basically, that is the basic decision that you are making under medical directive. You're not going to burden the family this way. When my father was dying, he had congestive heart failure. It came to the point where he was on a machine and he wasn't coming back. There was nothing left. He was on life support and that was it. But they didn't have a medical directive, and so my mother ultimately was the decision maker on this. And she agonized over it, for hours and hours, trying to decide what to do. And finally did decide that it was time to let him go, and they pulled the plug, and he eventually passed within hours. But she struggled with that decision for several years afterward, wondering if in fact she did make the right choice. So the whole reasoning for the medical directive is to take that burden away from the family and just allow you to be the one to make that decision.
Yeah, we've talked with so many people that have had to make that decision on their own, and decades later, they're still wondering if they made the right decision. We just can't do that to our families.
Then make sure your personal agent has a copy of this. And this is one thing that you don't keep aside in the file or in the PDF on your secure flash drive. This is something that they actually have to physically have, because if something should happen, then they've got the authority right then and there in case they need it.
And they need to show that documentation to the doctors.
Right.
There again, it's hearsay otherwise. Estate HIPAA form and aging parents. Well, let's learn what the HIPAA form is. It's an acronym for the Health Insurance Portability and Accountability Act. And really it was designed to create a big database so that doctors could share information about you. You might have your doctor's office here, but now all of a sudden you're in a hospital and they need information. They can just email that information, or they can go to the database, they can pull that information that they need. It also helps American workers and their families if they change or lose their job. But a little known fact about this that people are not utilizing, and that we want you to start utilizing, is that this form also allows someone you choose to talk with your doctor. And this is critical. The same thing with the medical directive. It's that documentation that says what's going on. But what we see going on around the country right now, and let's just talk about aging parents and driving. I've talked with people, I see articles from reputable companies that are saying, take the keys, sell the car, disable the car, do what you have to keep them from driving. And you don't have to do that, because if you are on your parents' HIPAA form, you can talk to the doctor. You're not a doctor. You can talk with the doctor. And what the doctor can do is, let's say you're concerned about dad driving. So you call the doctor and say, we got an appointment coming up. Family's really concerned about dad driving. Can you do some tests? Doctor's going to say, absolutely, I can do those tests. They can test them physically to see if they have any impairments there, reaction times, are they making good decisions, those kinds of things. And a doctor can say, you shouldn't be on the freeway. Or a doctor can go to the DMV department and revoke a license. Yep. We should not be doing that as kids. And as kids, we're creating a situation. Remember in one of the earlier sessions when I said the things that older people fear the most is somebody taking their keys, somebody taking their house, or somebody taking their money. And as an adult child, for you to put yourself in a position of trying to execute that, you're creating a rift with that parent. if you let the doctor do it, then you become in a support role. The doctor says, I'm sorry, John, you can't drive anymore because of this and this and that. And older people listen to their doctor. You listen to your doctor, right? We want to trust our doctors are saying the right thing. But you as an adult child then become a support mechanism for them. They're sitting in the doctor's office. They just heard that they can't drive. That's your chance in a loving way to say, Dad, I'm so sorry. I want to support you with this. We can find alternate transportation. You can still get to the places you want to go. You just can't drive there. I'm going to help you with that. You see the difference? You don't want to be the antagonizer in the family. You want to be the support person. And it's so easy to do it this way. In your estate plan documents, you can require notification from your doctor. We have. It's in our trust that our son needs to have a doctor's letter saying that we can't drive, or that we can't make good financial decisions, or we can't make other sound decisions. It takes that burden away from our son that may be worrying about us. And we don't want him to antagonize us. We want him to be a part of the loving family we've always been. So it's right in our estate plan what he needs to do. And you can need 2 doctors' letters. You could need 3 doctors' letters. It's your plan. Work it however you want, but put it in your estate plan documents so that you're taking that burden away from your kids. Simple, right? Easy peasy stuff. Not burdening your family. They're not doctors. We can't do this.
I think that another thing that we want to interject too about the HIPAA form and its value is when your 18-year-old goes off to college, and because of the policies of the colleges, you may not be able to access information about how they're doing if they do get ill while they're on campus.
Right. It serves from them. At 18 years old, our government cuts us from the herd. We become adults. We become individual citizens. And, a doctor, a hospital, a college may not be able to talk to us as parents because of these reasons. But if you whip out a state HIPAA form and say, no, I have authorization, tell me what's going on, then they're going to pass that information on. A lot of people don't know that.
You can find these forms online, or I'm sure your attorney will have access to them when you get to that point. We encourage you to continue to gather your information, to think about your family dynamic. As always, we invite you to ask questions by contacting us at alegacyundone.com. Until next time, thank you very much.
Thank you.